Good afternoon, ladies and gentlemen. This is your host, Elgin Martinez, from the Immigrant Edification TV, the only channel that addresses real immigrant issue. The video this afternoon is going to be about the new public charge rule that was passed under the Trump administration. What I'm going to do is basically read an article from uscis.gov. Alert, U.S. Citizen and Immigration Service, USCIS, will implement the inadmissibility on public charge grounds final rule on February 24, 2020, except in Illinois, where the rule remains enjoined by a federal court as of January 30, 2020. The final rule will apply only to application and petition postmarked or submitted electronically on or after February 24, 2020. For application and petition sent by commercial carrier such as UPS, FedEx, DHL, the postmark date is the date reflected on the carrier's receipt. When determining whether an alien is likely to become a public charge at any time in the future, DHS will not consider an alien's application for certification or approval to receive or receipt of certain non-cash public benefits before February 24, 2020. Similarly, when determining whether the public benefit condition applies to application or petition for extension of stay or change of status, USCIS will only consider public benefits received on or after February 24, 2020. What is a public charge and when does it apply? For purpose of determining inadmissibility, public charge means any individual who is likely to become primarily dependent on the government for subsistence, as demonstrated by either the receipt of public cash assistance for income, maintenance, or institutionalization for long-term care at government expense. A number of factors must be considered when making a determination that a person is likely to become a public charge. Under Section 21A, 4 of the Immigration and Nationality Act, INA, an individual seeking admission to the United States or seeking to adjust status to that of an individual lawfully admitted for a permanent resident green card is inadmissible if the individual at the time of application for admission or adjustment of status is likely at any time to become a public charge. Public charge does not apply in naturalization proceedings. If an individual is inadmissible, admission to the United States or adjustment of status is not granted. How is it determined whether someone is likely to become a public charge for admission or adjustment purpose? Inadmissibility based on public charge ground is determined by the totality of the circumstances. This means that the adjudicating officer must weigh both the positive and negative factors when determining the likelihood that someone might become a public charge. At a minimum, a U.S. Citizen and Immigration Service officer must consider the following factors when making a public charge determination: age of individual, health, family status, assets, resources, financial status, and education and skills. The officer may also consider any affidavit of support filed on behalf of the individual under Section 213A of the INA Presence or absence of a single factor cannot be the sole criteria for determining inadmissibility as a public charge, unless that factor is the absence or insufficiency of an affidavit of support when required by the laws and regulations governing a specific immigration benefit, such as certain family-based adjustment of status application. In assessing the totality of the circumstances, including the statutory factors above, an officer may consider the individual receipt of certain publicly funded benefits. Not all publicly funded benefits are relevant to deciding whether someone is likely to become a public charge. When determining whether someone is likely to become a public charge, USCIS will consider whether the individual is likely to become primarily dependent on the government for subsistence as demonstrated by either the receipt of public cash assistance for income, maintenance, or institutionalization for long-term care at government expense. Short-term institutionalization for rehabilitation is not subject to public charge consideration under existing field guidance. Non-cash benefits that USCIS does not consider are discussed in greater detail below. What public funded benefits may be considered for public charge purpose? Cash assistance, temporary assistance for needy families, TANF, state and local cash assistance programs that provide benefits for income maintenance, often called General Assistance Program, programs including Medicaid, supporting individuals who are institutionalized for long-term care, example in a nursing home or mental institution. Note, costs of incarceration for prison are not considered for public charge determination. Ladies and gentlemen, we've come to the end of this video. Please like, subscribe, share, hit the notification bell.